So what if the driver's license sitting in your wallet right now isn't actually a permit to drive, but like a secret commercial contract?
Oh, man.
Right. And
Oh,
and what if simply saying the word guilty or not guilty in a traffic court is this, calculated linguistic trap designed to totally strip you of your constitutional
I
rights?
mean, it literally sounds like the plot of a legal thriller or something.
Totally.
But for a very specific subset of people, this is the literal real-world interpretation of how the American legal system operates.
Yeah.
It's this worldview where every single word you speak to a judge is a liability, and where you, the individual, can supposedly just overrule a sitting judge from the comfort of your own living room.
Which is just wild to wrap my head around.
Yeah.
So welcome to another deep dive. We're really thrilled to have you with us today because we are setting out on a massive mission.
A huge one.
Yeah, we're going to unpack this highly specific, deeply controversial, and just incredibly intricate seminar on legal theory. And the source material you've shared with us for this comes from an organization called Court University.
Yeah, and it's a lot of material.
It is a massive stack of lecture transcripts, study guides, and crucially, there's also a clarification document generated by an AI that pushes back on all these theories with established mainstream legal precedent.
Right. And before we really get into the weeds of this, because there are a lot of weeds, we need to establish some very clear ground rules for our deep dive today.
Yes, definitely.
The material we're analyzing presents a completely alternative worldview regarding common law, statutory law, and personal sovereignty.
Uh-huh.
So our goal today is strictly educational, strictly analytical. We are going to explore these fascinating theories exactly as the seminar presents them, but we're simultaneously weaving in the established court pushbacks provided in your sources.
Right, because we are not taking sides here.
Exactly. We're not endorsing, we're not validating, and we are certainly not encouraging any of these legal strategies.
Please don't try this at home.
Yeah, please don't. We are simply dissecting the concepts to help you, understand the internal logic of this totally unique interpretation of the legal system.
Right. So think of us as your tour guides through a very, very complex legal philosophy. And to understand how this seminar tells you to handle something as, I don't know, mundane as a traffic ticket, you first have to understand how this worldview treats the very concepts of history and language.
Yeah, you really do.
Like, we literally can't even talk about traffic courts until we talk about ancient Rome and Vikings.
Which is such a crazy place to start, but that is exactly where the seminar begins.
Right.
According to the transcripts, the foundational premise of this entire legal strategy relies on this very specific historical narrative about how modern law was even formed.
Okay.
The seminar instructor argues that the legal system you and I interact with today isn't a single unified code.
It's not.
No, instead, they view it as this messy, kind of Frankenstein-like merger of three ancient systems of law.
Okay, so let's unpack those three systems because they really set up the whole hierarchy that this entire strategy relies on later.
Right.
The seminar identifies them as the North, the Roman, and the barbarian systems.
Correct. So let's start with the system from the north.
The Vikings.
Yeah, exactly. The Vikings and the early Anglo-Saxon traditions.
Hmm.
In their narrative, this is the absolute bedrock of what we call the common law.
Okay.
And the defining characteristic of this northern system is that power originates at the very bottom. Like
What?
power comes directly from the people.
So it's bottom up.
Exactly. In this framework, the rulers, the kings, the elected officials, they are strictly public servants.
Yeah.
The individual citizen is the ultimate sovereign authority.
Okay, so in that system, the individual is the boss,
Right.
but then the seminar introduces the Roman system, which they equate to modern civil law or like statutory law, right?
Yes. And the Roman system operates on a completely different philosophy of power.
Mm.
According to the seminar, the Roman system is a compromise. Well, you have a massive concentration of power at the top, right? Like an emperor or a dictatorial state. But you also have institutions at the bottom, like senates, tribunes, administrative courts.
Oh, it meets in the middle.
Right. These lower institutions act as buffers. They negotiate power between the state and the citizenry. So power doesn't flow purely from the people. It's negotiated through bureaucracy.
Oh, okay. And then there's the third one, which the seminar calls the barbarian system. And I have to say, when I first read this in the transcripts, it sounded a bit, I don't know, theatrical.
It does sound theatrical.
Yeah, but they actually tie it directly to the concept of divine right.
That's the key to understanding the barbarian component, yeah. The seminar explains that when various tribes conquered parts of the Roman Empire, their theory of governance was totally top-down, but with a spiritual mandate.
Like God put them there.
Exactly. The king, or the ruler, was placed there by divine providence. Therefore, all law and all power flowed from God directly to the king and then sort of trickled down to the people. Yeah, so in this barbarian system, the people have absolutely no inherent power or rights. They only possess the privileges that the king graciously grants them.
Okay, so how does the seminar weave these three, like, very distinct philosophies into the modern American legal system?
Well, they argue that history basically forced these systems to collide.
Okay.
When the Roman Empire expanded into regions governed by the northern common law, you had your first major merger. Later, when the barbarian tribes disrupted the Roman structures, a second merger occurred.
Great. That makes historical sense.
But here's the catch. Because the conquering tribes lacked the bureaucratic infrastructure to actually manage vast territories, they had to rely on the educated Roman administrators to run the day-to-day government.
Which means the bureaucracy survived.
Exactly. The bureaucracy always survives, right? So the seminar's ultimate conclusion here is that our modern system is a blend of all three, but heavily, heavily skewed toward the Roman and barbarian models.
Okay, so we're living in a Roman barbarian hybrid, basically.
Right? We have this massive statutory bureaucracy that dictates rules from the top down, acting as if they have the divine right to grant us privileges.
But what about the northern system? The people power?
Well, this is the crucial pivot for their entire legal strategy. The seminar claims that the foundational northern system, the common law, where the people are sovereign, was never legally abolished.
Oh, interesting.
Yeah, it is supposedly still the highest law of the land. It's just, buried underneath centuries of statutory Roman paperwork.
So if I'm understanding the logic of the source material correctly here, they're basically saying that the modern government operates like a Roman emperor handing out privileges.
Right.
But if you, the individual, actually know the correct legal maneuvers, you can kind of pull rank. Like, you can invoke the ancient common law and remind the government that they are actually your servants.
That is exactly the core objective, yes.
Wow.
But to pull rank, you have to understand how the government supposedly tricked everyone into submitting to the Roman statutory system in the first place.
Right, how did they trick us?
Well, according to the seminar, the ultimate weapon of the state isn't police or military force, it's language.
Language. Yeah. This was the part of the transcript that really made me pause. The idea that vocabulary is proprietary.
It's wild.
The seminar claims that words are literally owned by specific professions and jurisdictions.
It is a fascinating linguistic theory for sure.
Yeah.
The instructor uses a very relatable analogy to explain this.
Let's hear it.
Okay, imagine you run a standard retail business, right? You refer to the people who buy your products as customers.
Sure.
But if you go to a medical clinic, the doctor doesn't call you a customer, they call you a patient.
Right, you're a patient.
Well, the seminar argues that the word patient is proprietary to the medical profession. And by accepting the label of patient, you are implicitly agreeing to a specific relationship where you surrender a degree of your arm's length independent decision-making autonomy to the medical expert.
Like you're submitting to their authority by answering to that word. And they apply this exact same logic to the legal system. They point out that lawyers don't have customers either. They have clients.
Precisely. And in the logic of the seminar, the word client is a massive, massive trap.
Really? Why?
They warn that the moment you walk into a courtroom or a law office and declare yourself someone's client, you have legally stated that you are incompetent to handle your own affairs.
Wait, incompetent just by saying client?
Yes. You have handed your sovereign power over to an officer of the court, the attorney, allowing them to make binding commitments on your behalf.
I mean, it's like stepping into a casino.
Okay, I like that.
Yeah, if you sit down at the blackjack table, you can't use your own cash. You have to exchange your money for their chips.
Right.
So in this worldview, if you use their vocabulary words like client or defendant or passenger, you're using their chips.
Exactly.
And by using their chips, you are tacitly agreeing to play by the house rules. You're voluntarily stepping out of your protective common law jurisdiction and just subjecting yourself to their statutory jurisdiction.
That is an excellent way to conceptualize it. You are leaving your common law house and entering their statutory or equity house.
Wow.
And the seminar applies this proprietary linguistic theory to almost every aspect of the court system. Take the word record, for example.
Okay.
We all assume a court keeps a record of what happens, but the seminar claims that under strict historical definitions, only a specific type of common law court, a true court of record, has the authority to keep an actual binding record.
So what does a normal traffic court keep then?
They view standard traffic courts as inferior, corporate, administrative tribunals that merely keep a register of actions, not a true legal record.
They go so far as to trace the etymology of everyday administrative words to prove their point too.
Oh, yeah.
The origin of the word file was a real standout moment in the study guides for me. Because we think of a file as a folder or, a digital document on a computer.
Right.
But historically, the seminar points out, a file was a physical wire.
Yes. In older administrative systems, you would hand your paper to a clerk, and the clerk would literally hang that piece of paper on a wire suspended inside a bag.
Which is a fun historical fact, but why does that trivia matter to someone fighting a traffic ticket today?
Because the seminar uses that history to redefine the role of the court clerk entirely.
Okay.
If filing originally just meant hanging a paper on a wire, then the clerk is historically nothing more than a warehouseman.
Just a storage person.
Right. Their only job is storage.
Mm-hmm.
Therefore, the seminar argues, a clerk possesses absolutely no judicial authority. They cannot evaluate, reject, or judge the validity of the paperwork you submit. They simply have to take it and put it on the wire.
I see.
And this becomes a very crucial part of their administrative strategy later on.
Which brings us to perhaps the most important proprietary word in this entire deep dive, the word license.
Oh, man.
Yes.
This is where the philosophical rubber meets the road.
Yeah.
According to the seminar, we have completely forgotten what a license actually is in the eyes of the law.
Well, the source material delves into this historical claim about the popularization of licenses in America, and they point back to the post-Civil War South.
Right.
According to the transcript, governments during that era desperately wanted to maintain laws against miscegenation laws prohibiting mixed-race marriages.
Yeah, that's their claim.
But due to the shifting political landscape and, federal pressure at the time, they couldn't always rely on outright blanket bans. So the seminar claims they began heavily utilizing the concept of a license.
The underlying logic being that a license shifts the activity from a fundamental right to a state-granted privilege.
Exactly.
And to back this up, the seminar points to older editions of Black's Law Dictionary.
Right. They love Black's Law Dictionary.
They really do. And the strict traditional legal definition of a license in there is permission from a competent authority to do something that would otherwise be illegal, a trespass or a tort.
Permission to break the law. That is how they define it. A license is basically a contract that gives you immunity to engage in an activity that the state has otherwise deemed dangerous or illegal.
Right.
So if we follow the seminar's logic here, if a license is a contract granting you permission to engage in a regulated activity, what on earth does that mean when you apply it to driving a Honda Civic to the grocery store?
Well, this transition brings us to the absolute core issue of the seminar, and arguably the most famous aspect of this alternative legal theory.
Okay, here we go.
It's the linguistic and legal distinction between traveling and driving.
Let's really explore this, because I imagine almost everyone listening to us right now has a state-issued driver's license in their wallet or purse.
I know I do.
Same. We view it as a basic rite of passage. But the seminar claims that we have fundamentally misunderstood what that little plastic card actually authorizes us to do.
Yeah.
And they base this entire argument on Title 18 of the United States Code, Section 31.
Right, because the seminar argues that federal definitions supersede state definitions. So they lean heavily on Title 18 to define what a motor vehicle actually is.
What does it say?
According to the statute they cite, a motor vehicle is defined as a self-propelled contrivance used in commerce.
Used in commerce. That phrase right there is the linchpin of the whole argument.
Exactly. And the seminar goes further to define what used in commerce means in this specific context.
Which is?
It means carrying passengers or cargo for hire. It means you are being financially compensated to transport people or goods. You are effectively operating a business venture on the public, taxpayer-funded roadways.
Okay, so the seminar's conclusion is a massive logical leap based on those definitions.
That's huge.
They state that if you are just commuting to your office or, driving to pick up your kids from school, and no one is paying you a fare to do so, you are not legally driving, and the machine you are operating is not legally a motor vehicle under the commercial definition.
In their vocabulary, you are simply traveling in an automobile or traveling in a private conveyance.
It's just traveling.
Yeah. You are exercising a fundamental, constitutionally protected right to free movement. You are not engaging in a regulated commercial privilege. Therefore, the commercial codes, the vehicle codes, the traffic laws, they simply do not apply to you.
Okay, but if I can just push back on the seminar's logic for a second here.
Please do.
Let's say I accept their premise about commerce. The reality is I still went to the DMV. I willingly filled out the paperwork, I took the eye exam, I signed on the dotted line, and I accepted the physical driver's license card.
Right.
Doesn't that signature mean I agreed to their rules? Haven't I entered into that commercial contract anyway, regardless of whether I'm currently hauling cargo for hire?
The seminar anticipates that exact pushback. They know you're going to ask that.
Oh, they do?
Yeah. And they address it using a very specific analogy. The marriage license.
Wait, how does a marriage license connect to a traffic stop?
The instructor asks the audience to consider this scenario. If you are legally married and possess a state-issued marriage license, does that mean a highway patrol officer can pull you over on the interstate and write you a ticket based on the authority of your marriage license?
Well, obviously not.
Right. And why not? Because in legal terms, there is no subject matter jurisdiction.
Okay.
The marriage license only activates and only grants the state jurisdiction over you when you are dealing with matters explicitly related to marriage, like a divorce or alimony.
I see where this is going.
The seminar applies this exact same concept to the driver's license. They argue that your standard driver's license is, in reality, a commercial driver's license.
So the contract exists, but it's dormant.
Precisely. They argue the contract only activates when you are actively engaging in the specific subject matter it regulates, which is commerce.
Right.
So if you are hauling a load of lumber for a paying client, the license is active and the highway patrol has jurisdiction. But the moment you drop off that lumber, stop getting paid, and drive home, the commercial jurisdiction evaporates. The license becomes dormant. You revert to a private citizen exercising your fundamental right to travel.
Wow. This requires a total linguistic remapping of everyday life.
It really does.
And the study guides are absolutely adamant about this. You can't just change how you think, you have to change how you speak.
Yeah, you have to be so careful.
For example, if a police officer pulls you over and asks, "Who are your passengers?" You cannot say, "These are my passengers."
No, because according to their proprietary language theory, passenger is a commercial term.
Really?
Yeah, they claim it historically derives from the concept of a passport someone authorized to board a commercial vessel who is paid a fare.
Right, so you have to say, "I have no passengers, these are my guests."
Exactly. You are constantly managing your vocabulary to avoid accidentally triggering that commercial jurisdiction and stepping into their statutory casino, as you put it earlier.
It is just an incredibly intricate, self-contained logical loop.
It is.
But here is where we need to introduce a massive reality check. Because the sources you provided didn't just include the seminar's theories. They included a clarifying AI document designed to impartially present how the actual established legal system views these exact arguments.
Which is very important context.
Extremely. We have to look at what happens when this linguistic philosophy hits the harsh reality of a physical courtroom today.
And the reality presented in the AI document is stark. It is not pretty. Established courts across the entire United States have consistently, uniformly, and forcefully rejected this distinction between traveling and driving.
Yeah, they don't just disagree with it, they shut it down completely.
Absolutely. The courts draw a very sharp, very different distinction than the seminar does. The established legal system absolutely agrees that the right to travel interstate is a fundamental constitutionally protected right.
Right, no state can build a wall and stop you from moving.
Exactly. You can walk across state lines, you can ride a bicycle, you can take a Greyhound bus, you can fly on a commercial airline. The government cannot prevent your fundamental movement.
But there is a massive but coming, isn't there?
There is a huge but. The courts have definitively ruled that operating a 2-ton piece of heavy machinery at 70 miles per hour on public, taxpayer-funded roadways is a specific mode of transportation.
A mode.
Right. And the government has a compelling overarching interest in regulating that specific mode of transportation to ensure public safety.
Which makes sense.
Therefore, the established law dictates that driving a motor vehicle on public roads is a conditional privilege, subject to state regulation, licensing, and policing. It is not an unfettered fundamental right.
You know, the way I conceptualize the court's view is by comparing it to the First Amendment.
Okay, how so?
So I have a fundamental right to free speech. That right is guaranteed. But that doesn't mean I have the right to walk into a packed, taxpayer-funded football stadium, commandeer the public address loudspeaker without a permit, and start shouting my opinions.
Oh, that's a good analogy.
Right. The speech itself is free and protected, but my use of the stadium's loudspeaker is a specific mode of expression that the stadium authorities can absolutely regulate for safety and order.
That analogy perfectly captures the established legal perspective, actually.
Mm-hmm.
The right to travel is your free speech. Driving the car is using the loudspeaker.
Exactly.
And the AI document notes that courts have routinely labeled these freemen on the land or sovereign citizen arguments as frivolous and without any legal merit whatsoever.
And the real-world consequences for trying to use these theories are severe. I mean, the document warns that if you attempt to use the "I'm traveling, not driving" argument during a traffic stop, you aren't going to outsmart the officer.
No, you're really not.
You are highly likely to face escalated fines, have your vehicle immediately impounded, and potentially face arrest for driving without a license, resisting arrest, or failing to comply with a lawful order.
Yeah, the established system does not play along with a vocabulary game. They just don't.
Yeah.
However, what is truly fascinating about the Court University seminar is that they fully acknowledge this.
They do.
Yeah. They know the system will fight back. The instructor doesn't promise that a police officer will hear your logic and just let you go. In fact, they expect the police and the lower courts to forcefully reject it.
Which means the seminar isn't just a philosophy class, it's a strategic manual.
Exactly.
Because they expect the system to push back, they have mapped out a highly aggressive, deeply psychological strategy for dealing with the courts. They basically view it as a form of legal warfare.
Yes, administrative warfare.
So let's pivot to Section 3 of the outline. Let's say you do get pulled over and you do get a traffic ticket. According to this alternative worldview, what are you supposed to do before you ever set foot in a courtroom?
Well, the seminar advocates for a strategy of proactive administrative warfare, like I said. The core idea is that you never want to fight the state on their turf, which is the courtroom, if you could defeat them on paper beforehand.
Okay, so how do you do that?
They outline two primary options for dealing with the state prior to a hearing.
Option 1 is what the instructor calls the preemptive strike. And it actually advises you to avoid getting pulled over in the first place, right?
Right. The instructor is surprisingly pragmatic about police encounters. They explicitly advise against getting into roadside debates about constitutional law with armed police officers.
We're all smart.
Because the officer has the immediate physical power. Instead, the seminar suggests a more strategic, peaceful approach. You comply initially. You go get a standard driver's license.
Wait, I thought the whole point was that you don't need one.
You don't need one in their theory, but you get one to avoid the roadside arrest.
Okay.
Then once you have the license, you go on the offensive. You turn around and sue the state for what is called a declaratory judgment.
Okay, I need you to explain a declaratory judgment, because in my mind, a lawsuit is about suing for money or damages. How do you sue a state just to ask a question?
A declaratory judgment is exactly that. It's a legally binding request for a court to clarify your rights under a specific statute or contract without necessarily seeking financial damages.
Interesting.
In this strategy, you file a lawsuit against the state declaring, I intend to travel privately on the roadways without engaging in commerce. Under the strict definitions of Title 18 and the state commercial codes, do I legally require this license to do so?
So you are forcing a higher-level judge to go on the record and interpret the definitions of motor vehicle and commerce as they apply to your private commute.
Exactly. The seminar's theory is that if you can corner a judge into reading the strict statutory definitions, they will have to admit that private travel isn't commercial driving.
Wow.
And if you win that declaratory judgment, you receive a court order validating your status. The strategy is to then take that court order to the DMV and force them to update your administrative file.
So that it's in the system.
Right. That way, if a police officer runs your license plate in the future, the computer system flags you as legally exempt from standard traffic codes, preventing the ticket from ever being written in the first place.
Okay, conceptually, I see the logic they're applying. But practically speaking, filing for a declaratory judgment against the state sounds incredibly complex, time-consuming, and expensive.
It is. All of those things.
What about the average person who just got a $150 ticket for rolling through a stop sign? They aren't going to mount a multi-year constitutional lawsuit.
No, they're not. Which is why the seminar provides option 2, designed specifically for your average run-of-the-mill traffic ticket.
Okay.
And their advice for this scenario is a complete subversion of what you might expect. They tell you, Do not fight the ticket.
Don't fight it, but the whole seminar is about how the ticket is fraudulent.
I know, but it's about resource management and jurisdiction.
Yeah.
The seminar views the local traffic court as a rigged, inferior corporate tribunal.
Right. It's their casino.
Exactly. If you go to traffic court and try to defend yourself against a speeding ticket, you are walking into their casino using their chips and playing by their rules. By defending yourself, you validate their authority to judge you.
So the strategy is a calculated retreat, a laydown.
Precisely. The instructor advises you to just pay the fine, pay the bail, write the check, and end the immediate threat.
Just like that.
Well, no. However, you do not just pay it blindly, you pay it conditionally, using a very specific legal mechanism.
This is where we get into the Uniform Commercial Code, the UCC. The study guides are just obsessed with UCC, Section 1308.
Yes, the U.C.C. It's a massive set of standardized rules that govern commercial transactions and contracts across the United States. It's what allows a business in New York to easily enforce a contract with a business in California.
Right.
Because the seminar views all state interactions, including traffic tickets, as secret commercial contracts, they believe the UCC is the ultimate rulebook that governs the state.
So how do you use UCC 1308 to pay a ticket conditionally?
UCC 1308 is the section dealing with the performance or acceptance under reservation of rights.
Okay.
The seminar instructs you to write your check for the traffic fine, but right above your signature, you must write the words "without prejudice" and cite UCC 1308.
What does writing without prejudice mechanically do in this worldview? Like, what's the point?
In mainstream legal terms, reserving your rights means you are complying with the demand under protest, ensuring that your compliance cannot be used as evidence that you agree with the demand, and preserving your right to challenge it later.
Okay. And in their worldview?
In the seminar's theory, writing "without prejudice" on the check means, I am giving you this money because you were extorting me under threat of violence or arrest, but I am not admitting fault, I am not accepting your commercial contract, and I am explicitly reserving my right to sue you for this extortion.
It's a linguistic shield.
Yep.
The transcripts even give advice for what to do if the court clerk tries to refuse the check. Because apparently clerks know this trick and will hand the check back, saying they can't accept altered documents.
Yeah. The workaround they suggest is pretty clever. They say to print the words "without prejudice UCC 1308 directly inside the signature box on the ticket or the check, and then sign your actual name over the top of the letters.
That's sneaky.
The logic is that the clerk cannot alter, white out, or cut away your reservation of rights without legally destroying the signature that validates the check. They have to accept the whole package.
Okay, so you've paid the ticket without prejudice. You are out $150. You lost the money. How is this possibly a victory in the seminar's eyes?
Because of the massive psychological and strategic pivot it allows. Think about what happens when you get a ticket. You are anxious, you are on the defensive, you are worried about warrants and insurance rates.
It's super stressful.
By paying a ticket, you instantly neutralize all of that state power. The threat of arrest is gone. The harassment stops. You have bought your peace.
But because you reserved your rights, the issue isn't legally dead.
Exactly. You have preserved the dispute.
Yeah.
Now, you can take all that anxious energy you would have spent playing defense in the rigged traffic court, and you pivot 180 degrees.
You go on the attack.
You launch an offense.
You stop being the defendant, and you become the plaintiff.
This is the crux of their administrative strategy. In their interpretation of common law, there is no statute of limitations on fraud or extortion.
Aye.
So you pay the ticket to get them off your back. Then immediately, or a month later, or a year later, you file a counterclaim or an original lawsuit against the state, the court system, or even the individual police officer.
As the lecturer vividly puts it, you challenge their jurisdiction 3 microseconds after being accused. But you do it on your own terms, in a higher court under the common law.
Yes. By becoming the plaintiff, you entirely shift the burden of proof. When you are a defendant in traffic court, you are trying to prove you weren't speeding. When you are the plaintiff in a common lawsuit, you demand that the state prove to your court where they derive the subject matter jurisdiction to apply commercial vehicle codes to your private, non-commercial travel.
You put the state on trial.
Exactly.
And this entire offensive campaign is waged through a very specific, heavily ritualized paperwork process known as notice and demand.
Notice and demand is the absolute foundation of their administrative warfare. It is a process of establishing facts outside of a courtroom.
How does it work?
You draft a formal letter, A notice outlining your legal facts. You state that you were traveling privately, not engaging in commerce, and that their ticket was an act of extortion. You demand that they produce evidence to the contrary.
And the logistics of how you send this letter are treated with absolute reverence in the study guides. You don't just email it or drop it in a mailbox.
Oh, no.
You send it via registered mail, return receipt requested.
The physical paper trail is everything. You need absolute, undeniable proof that a specific agent of the state received your specific document on a specific day, because what happens next is based entirely on contract law.
The concept of dishonor. This was fascinating to me.
It's very unique.
If you send this dense, sovereign legal document to a local police chief or a traffic clerk, there is a 99% chance they're going to look at it, roll their eyes, and throw it in the trash. They are going to ignore it completely.
And in the seminar's legal framework, the state ignoring your letter is the absolute best case scenario.
Why? I would think you want them to respond.
Because they apply strict commercial contract rules to this administrative interaction. In contract law, if someone sends you a formal sworn claim and you fail to rebut or deny those claims within a specific time frame, your silence can be legally construed as acquiescence.
Wow. Silence is a confession.
Yes. By failing to rebut your affidavit, the state is considered to be in dishonor.
Dishonor.
They have legally agreed to your facts by default. You claimed you weren't driving in commerce, and because they didn't write back to deny it, they have legally admitted you weren't driving in commerce.
But the seminar warns that you can't just send one letter, wait 30 days, and declare victory. You have to demonstrate reasonableness. You have to grant the state what they call grace.
Right. It's a three-step ritual. You send the first notice and demand. They ignore it. So you send a second document, often called a notice of fault.
Okay.
This letter formally informs them that they missed the deadline and are in dishonor. But being a benevolent and reasonable sovereign, you are granting them a grace period, perhaps another 10 or 15 days, to correct their error and respond.
And if they ignore the grace period, too.
Then you issue the final notice of default. You have now established an unassailable physical paper trail, proving that the state was given multiple opportunities to justify their jurisdiction, and they completely failed. You have built a binding administrative record of facts that theoretically cannot be challenged later in court because the state already forfeited their right to argue by remaining silent.
While you are engaging in this months-long paper war, the seminar places a massive emphasis on monitoring the court's physical docket. The lecturer gives a very specific, almost paranoid piece of advice. You must go to the courthouse and physically check your file every 2 weeks, every 14 days.
This reveals the deep, deep distrust this worldview holds for the legal system. The 14-day rule is actually based on procedural math.
Yeah, I'm glad to hear the math.
In most jurisdictions, when the opposition files a motion, you have roughly 20 days to file your response.
Right, the clock starts ticking.
The lecturer suggests a hypothetical, or perhaps, in their mind, very real scenario where a malicious clerk or prosecutor files a motion to dismiss your case, but intentionally throws your copy in the trash instead of mailing it to you.
That's sinister.
If you don't know the motion exists, you miss the 20-day deadline, and you lose by default.
So why 14 days?
Well, by physically checking the docket every 14 days, you guarantee that even if a document was filed and hidden from you on day 1, you will discover it by day 14. This leaves you with at least 6 days remaining to scramble and draft your response before the 20-day clock expires. It's a logistical safeguard against perceived systemic corruption.
It sounds exhausting, just going to the courthouse every 2 weeks. And what happens when you take your painstakingly crafted notice of default down to the courthouse to file it, and the clerk at the window looks at this sovereign citizen paperwork and flat out refuses to accept it? Like, I'm not filing this gibberish.
This brings us back to the historical definition of the clerk as a mere warehouseman. The seminar teaches a technique called file on demand.
You essentially force them to do their job.
You firmly, politely but relentlessly demand that the clerk date stamp the document and place it in the file. You remind them they are not a judge and have no authority to evaluate the content.
But why is the physical stamp so important if the clerk obviously hates the document?
Because the date stamp is your physical proof of the clerk's resistance.
Yeah.
It proves to the judge later on that you, the litigant, knew the rules of the game so well that you forced a recalcitrant clerk to perform their ministerial duty.
I see.
It demonstrates that the state tried to block your sovereign paperwork, but you successfully forced it into the record anyway.
Okay, so you've navigated the administrative minefield. You've sent the notices, granted the grace periods, monitored the docket, and forced the clerk to stamp your paperwork. You've built your perfect common law record.
You ready?
But eventually, all this paperwork leads to an actual physical hearing. You have
Yeah.
to show up in a courtroom. And Section 4 of the seminar outlines a strategy for the physical courtroom that is. Frankly, it's entirely theatrical.
Theatrical is the perfect word. The seminar explicitly states that you must completely discard your preconceived notions of what a courtroom is.
It's not about justice.
No, it is not a place where justice is discovered or truth is debated. A courtroom is a stage.
A stage. Literally a theater production.
Yes. The lecturer describes it as a stage upon which the sovereign conducts a show to satisfy the rest of the world that their ultimate decision is fair and legally sound.
So who is the audience for this show?
That is the critical shift in perspective here. You are not there to convince the judge of anything. You're certainly not there to convince the prosecutor.
You're not.
No. In the seminar's view, the judge and the prosecutor are co-conspirators. They already know the game is rigged. They know the statutory system is a usurpation of the common law. Arguing with them is totally pointless.
So you are performing for everyone else in the room.
Exactly. You are putting on a show for the court clerks, the bailiffs, the sheriffs, the jury if there is one, and the public gallery.
Wow.
Your goal is to appear so perfectly compliant, so remarkably polite, and so procedurally flawless that it forces the judge to either concede to your authority or openly break the law in front of all those witnesses, exposing their own corruption.
And the very first trap on this stage, the very first moment they try to pull you into their jurisdiction, is the arraignment. The moment the judge looks down at you and asks the standard everyday question, how do you plead? Guilty, not guilty, or no contest?
The seminar warns that this is the absolute most dangerous moment in the entire process. Choosing any of those three options is fatal to your legal strategy.
I understand why pleading guilty is bad, but why is pleading not guilty a trap? Doesn't that just mean I want a trial?
Normally, yes, but think about the proprietary language we discussed earlier. By answering the question and entering a plea, even a plea of not guilty, you are tacitly acknowledging two things.
Okay, what are they?
First, you are acknowledging that the court has the legitimate subject matter jurisdiction to ask you the question. Second, you are agreeing that the specific commercial or statutory code they are accusing you of violating actually applies to you.
You are stepping up to the blackjack table and accepting their chips.
You are opting into the Roman statutory system.
So what on earth is the fourth option? If you can't plead guilty, not guilty, or no contest, what do you say when the judge demands an answer?
You refuse to enter a plea. You state, for the record, that you object to the entire proceeding based on a fundamental lack of subject matter jurisdiction.
This flat-out object.
You are telling the court, you do not have the legal authority to ask me that question regarding this subject.
And this brings us to the golden rule of the entire in-court strategy. The seminar cannot emphasize this enough. They repeat it over and over. Do not, under any circumstances, verbally discuss the facts of your case in court.
It goes back to the idea that judges and attorneys are word masters.
Word masters.
Right. They are highly trained professionals whose entire job is linguistic manipulation and interpretation. The seminar introduces a very specific legal concept to explain why silence is your only defense. Novation.
I need you to explain novation because this seems to be the linchpin of why sovereign citizens act so strangely in court videos.
Novation is a contract law concept. It means the substitution of a new contract for an old one, or a new modification that overrides previous agreements.
Okay.
In this sovereign framework, they apply novation to courtroom procedure. They believe that any word you speak verbally in the courtroom is considered a real-time novation.
Meaning your spoken words override your written paperwork.
Exactly. You may have spent 3 months building a flawless, unassailable paper trail of affidavits and notices of default, proving you weren't driving in commerce.
Yeah.
But the moment you stand in front of the judge and say something like, "But Your Honor, I was only driving 45 miles an hour," you have committed a novation.
Because by arguing the facts, you just admitted you were driving.
You just validated their jurisdiction. The judge will instantly seize on your spoken words, use them to establish jurisdiction, and legally nullify your entire meticulously crafted written record.
That's terrifying if you believe the theory.
The seminar warns that if you try to argue legal philosophy with a judge, you will lose, because they control the linguistic rules of the courtroom.
So they provide a script to prevent you from committing innovation. If the judge asks you a question about your case, or challenges your paperwork, you literally just repeat a single phrase. I have nothing to say. It's all in my filed papers, Your Honor.
You defer entirely to the physical record you built during the administrative phase.
Ah.
You absolutely refuse to engage in verbal sparring.
But wait, notice the end of that script. Your Honor. If this whole system is about refusing to submit to the state's authority, doesn't calling the judge Your Honor mean you are submitting to them? Aren't you acknowledging they are superior to you?
It's a good question. And the lecturer specifically clarifies this point because it's a common point of confusion. They explain that using the term Your Honor is merely acknowledging the judge's job title, much like calling someone officer or doctor.
So it's descriptive, not submissive.
Right. It does not surrender your personal common law sovereignty. It simply maintains politeness and courtroom decorum. And remember the concept of the stage. Politeness is vital for the show you are putting on for the observers.
The optics are everything. The etiquette is treated as a strategic weapon.
Oh, absolutely.
The seminar is obsessed with being overwhelmingly nice. You don't go in screaming about your constitutional rights or yelling that the flag has gold fringe on it. You smile at the police. You are incredibly polite to the clerks, even when forcing them to stamp your paper. You attempt to depower the system through extreme, unyielding cooperation.
Because anger is a liability. If you're angry and combative, you look unreasonable to the jury, the bailiffs, and the public gallery.
You look like a problem.
Right, and the judge can easily dismiss you as a crank or hold you in contempt. But if you are impeccably polite, well-dressed, and calm, you look like the rational, innocent victim of an overreaching, tyrannical system. You win the psychological war in the room.
Speaking of being well-dressed, we have to talk about the hyper-specific clothing detail in the study guide.
Oh my goodness, the tie.
It advises you to wear a nice suit to court, but if you choose to wear a tie, the stripes on the tie must flow in a very specific direction. They must go from your upper right shoulder down across your chest to your lower left hip.
They explicitly label this the sovereign direction.
The logic here is pure magical thinking. The theory is that a highly educated, top-level judge, one who truly understands the secret histories of common law and statutory jurisdiction, will look at you, spot the direction of the stripes on your tie, and immediately realize, this person understands true sovereignty. I better watch my step and respect their rights.
It's like a secret handshake woven into silk.
Yeah.
It underscores the incredible level of detail in this worldview and the profound belief that the legal system is filled with hidden symbols and esoteric codes that only the initiated understand.
But the seminar is also realistic. Despite the nice suit, the correct tie stripes, and your absolute refusal to commit a novation, things are probably going to go wrong.
Yes, inevitably.
The judge is going to reject your paperwork and make a ruling against you.
The judge will almost certainly overrule your objections and attempt to force the statutory procedure forward.
So what is the script for that?
Right.
You can't argue the law, you can't debate the facts, so how do you fight back in the moment?
You use the objection script. It is meticulously designed to register your dissent for the physical court reporter's record without engaging in a debate that could trigger a novation.
Let me walk through exactly how the transcript maps this out. It's a precise call and response. The judge issues an order you don't like, you stand up and say, I object.
And the judge looks at you and asks, why?
You reply, it is not my wish.
The judge, who is almost certainly annoyed at this point, says, overruled.
And you finish the interaction by stating, for the record, I do object.
That final statement is the tactical objective. By saying, for the record, I do object, you have successfully placed your dissent into the physical transcript.
Right.
You didn't argue case law. You didn't explain your philosophy. You didn't give the judge any words to twist into a novation. You simply established that the magistrate acted against the express wishes of the sovereign, which is you.
Okay, so you survived the physical hearing. You didn't argue, you just objected. Your tie stripes are going the right way, but it didn't work.
I rarely guess.
The judge still ruled against you, you got fined, or your motion was dismissed. Now what? We are moving into Section 5, Strategy After Court.
This is where the seminar's legal philosophy reaches its absolute zenith. This is where the concept of the court of record becomes your ultimate weapon.
We mentioned this briefly earlier, but we need to dive deep into it now. The seminar relies heavily on older historical editions of legal dictionaries, specifically Black's Law Dictionary, 4th edition, to define what constitutes a true, unassailable court of record.
Right.
And there are 4 strict requirements.
Requirement 1, the court must keep a physical record of the proceedings.
Makes sense.
Requirement 2, The court must possess the inherent power to fine or imprison people for contempt.
Okay.
Requirement 3. The court must proceed according to the common law, utilizing ancient causes of action like trespass, rather than relying on modern statutory codes.
And then there is requirement 4, the killer requirement that turns the entire justice system inside out.
Requirement 4 states, the tribunal must be independent of the magistrate.
Okay, we have to unpack this entirely because this is the wildest, most audacious twist in the entire seminar.
It really is.
Who is the tribunal and who is the magistrate?
To understand the twist, you have to look at a normal court. In a standard statutory traffic court, the judge acts as both. The judge is the magistrate who runs the procedural mechanics of the courtroom, and the judge is also the tribunal who makes the final decision on guilt or innocence.
They wear both hats.
Exactly. But in the seminar's common law framework, if you have properly established a court of record through your pre-court paperwork and your notices, you, the sovereign plaintiff, are the tribunal.
I am the tribunal.
You are the ultimate authority in the room. The judge sitting on the bench in the black robe is merely the magistrate. And in this strict interpretation, the magistrate's job is purely 100% ministerial.
So it's like the judge is just the referee at a gladiator match.
Right.
Their only job is to make sure the sand in the arena is clean, the gates are open, and the rules of engagement are followed. But I am the emperor, sitting in the VIP box, giving the thumbs up or thumbs down. The referee cannot declare the winner. The judge is actually prohibited from making a legal decision.
That is exactly how they view it. The sovereign decrees the law. The magistrate merely facilitates the paperwork.
Wow.
So under this operating logic, what happens when the magistrate, the judge, inevitably oversteps their bounds and issues a statutory order against you?
You just go home. You go home to your living room and turn on your word processor.
You leave the theater and you draft a legal document known as a writ of error. Because you are the legally established sovereign tribunal of this specific court of record, you possess the supreme authority to review the magistrate's rogue actions. You issue this writ of error to legally, formally reverse whatever order the judge just made in the courtroom.
You literally cancel the judge's order from your couch. The judge say, I owe $150. I, the tribunal, say the judge is wrong, order reversed. It is breathtaking in its audacity.
It is the ultimate expression of the power from the bottom philosophy we discussed in Section 1. And the seminar takes it a step further. What if you issue your writ of error and the judge just ignores it and proceeds to try and collect the fine anyway?
You, as the tribunal, find the sitting judge in contempt of court.
You issue a contempt order against the magistrate. And the seminar literally suggests that you fine the judge $1 for their infraction.
A single dollar? Why not $1 million?
Because the financial amount is irrelevant. It's entirely about the psychological establishment of authority.
Oh, I see.
By fining a judge $1, you aren't trying to bankrupt them. You are building a permanent paper trail that proves, for the historical record, that the judge is operating outside of the law, acting as a rogue agent, and willfully ignoring the lawful orders of the sovereign tribunal.
But to back all of this up, to issue these writs and contempt fines, you need absolute proof of what happened in the courtroom. And the seminar explicitly states that you cannot trust the official court reporter's transcript because they work for the state.
The state controls the record, so they can alter the record. To counter this, the seminar instructs you to bring your own witnesses to the hearing. You bring 2 reliable people who sit quietly behind you in the public gallery. They don't speak, you just watch.
And when you get home to draft your writ of error,
You have your 2 witnesses draft and sign sworn affidavits under penalty of perjury, detailing exactly what the judge did and said. Those private affidavits become your true, impenetrable record of facts.
And then we run into the final administrative hurdle. You take your writ of error, your $1 contempt fine against the judge, and your sworn witness affidavits down to the courthouse to file them.
Good luck with that.
Right. The clerk is going to look at this paperwork attempting to overrule their boss, the judge, and they are going to absolutely refuse to take it.
Which brings the strategy full circle back to the file-on-demand stamp.
Right.
You do not ask for permission. You relentlessly force the clerk to stamp the documents, utilizing their status as a mere warehouseman, thereby forcing your sovereign orders into the state's physical system.
But let's look at the ultimate endgame here. Let's say you do everything perfectly. You send the notices, you remain silent, you issue the writs, you fine the judge $1, and the court system just completely ignores you.
Which they will.
They bulldoze right over your paperwork, they hold a trial without you, they convict you, and they send it to collections. What is the sovereign's response when the system refuses to break?
The seminar lecturer offers a fascinating, almost stoic, final piece of philosophical advice for this exact scenario. Let them make errors.
Don't try to stop them. Don't file an emergency appeal.
Do not educate the court. Do not beg them to do the right thing. If they ignore your notice and demand, let them. If they ignore your counterclaim, let them proceed. If they blatantly violate the rules of a common law court of record to secure a conviction, let them do it.
What is the strategic value in letting yourself get convicted?
Because in this framework, every time the state ignores your perfectly filed, procedurally flawless common law paperwork, they are compiling legal errors. They are building a massive, documented case against themselves.
Playing a long game.
Exactly. The long-term strategy is to let the state die on its own errors. The belief is that eventually, when the dust settles, and this case is reviewed by a truly competent, high-level authority, perhaps a federal court or an international tribunal, the local court's judgments will be revealed as so permanently flawed, so steeped in documented fraud and prejudice, that the entire conviction will inevitably collapse under the conceptual weight of the paper record you built.
It is a game of infinite patience and absolute faith in the paperwork.
It really is.
Wow, so what does this all mean? We have gone on an incredible, deeply complex journey today.
We covered a lot of ground.
We started by exploring the supposed linguistic origins of licenses in commerce in the post-Civil War era. We examined the massive logical leap required to redefine the difference between driving a motor vehicle for commercial hire and traveling privately in a personal conveyance.
Right.
We walk step by step through a highly scripted, intensely psychological warfare manual, from the proactive administrative strikes and notice and demand grace periods to the absolute disciplined silence of the courtroom stage, right down to the astonishing audacity of issuing sovereign orders from your living room to overrule a sitting judge and fine them $1.
It is a truly dizzying interpretation of the law.
Yeah.
But here is the essential takeaway for everyone listening to this deep dive. Even if you never attempt a single one of these tactics, and again, the established courts heavily penalize these actions, so we strongly advise against it. There's a profound conceptual lesson here.
What's that?
This entire framework highlights how incredibly dependent our society is on the agreed-upon definitions of words. It forces us to recognize that understanding the underlying structure of a system, whether you are dealing with common law, statutory law, or just basic corporate administrative procedure, completely changes how you interact with authority.
The rules of the game change entirely depending on which house you believe you're standing in, and the words you use dictate which house you belong to.
Exactly.
We've talked entirely about traffic courts, vehicle codes, and driving today, but according to this seminar, the state uses this linguistic methodology everywhere.
Everywhere.
So if a driver's license is actually just a dormant commercial contract, and our legal system is built on these intricate proprietary linguistic traps, where everyday words like patient, client, record, and file hold secret contractual weight, it begs a massive question.
A really big one.
What other everyday privileges in your life, things you assume are just standard bureaucracy, are actually binding commercial contracts you signed away your rights to without ever realizing you were stepping up to the blackjack table?
Something to think about.
Definitely. We are so glad you joined us for this deep dive into the hidden mechanics of legal theory. Thank you for listening, and keep questioning the words you use every day.